Aloha, everyone, and welcome to Civil Beat's Ideas Live show for Wednesday, March 10th, 2021. We're glad to have you with us. We'll be here for the next hour or so. We're live, so we hope that you will feel free to join us with questions, with comments. Today, we are talking about bail reform. Today's show was inspired by an essay that Robert Merce wrote for us that ran in the Ideas section of Civil Beat on February 21st, and Bob's article was called Restore Justice, End the Cash Bail System. And Bob is here with us today. We're really glad to have you with us, Bob. Bob is a retired attorney who's active in criminal justice reform, and he's also on the board of the Native Hawaiian Legal Corporation. We also have Jacquie Esser with us. Jacquie Esser has been a public defender in Honolulu for the last 11 years. Jacquie, we're so glad to have you with us. Jacquie ran for prosecuting attorney recently, and she received a number of significant endorsements from progressives across the country, including Senator Bernie Sanders. And we are really, really grateful and excited to have with us all the way from Illinois, Sharon Mitchell Jr. Sharon is a former trial attorney with the Cook County Public Defender's Office, the director of the Illinois Justice Project, and he just found out today that he has been nominated to become the next public defender for Cook County. We're really happy to have Sharon here with us. And Illinois just passed a piece of legislation that Sharon described as the most progressive piece of pretrial reform legislation that this country has ever seen. So and this legislation completely eliminated cash bail. So we're really looking forward to hearing what happened in Illinois, how that came to pass. That legislation, it's brand new. It was just signed into law at the end of last month. So Sharon, welcome to Hawaii.
Thank you so much. I wish I were with you guys in person. Nobody sent me a plane ticket, but I know it's a pandemic, but I'm happy to be with you over Zoom, and I look forward to the conversation.
Thank you. Thank you. So what we love to do with these shows is to start them by having each one of our guests tell us how they came to arrive at the feelings that they have about the topic that we're discussing, what their experience has been that brought them to the understanding that they have of the topic. And so when we look at the whole question of cash bail, you're all here because you have strong feelings about it. And it would be great if we could start off by talking about your own experiences. You're all attorneys, of working within the system, of coming to understand the way the cash bail system functions and why you felt reform was needed. So Sharon, we would love to start with you.
Yes, first again, thank you so much for having me. I started off as a public defender in Cook County. Cook County is the county that incorporates Chicago and a couple more million folks. And as a Cook County public defender, I had lots of really difficult things to do, but one of the hardest things to do was to have conversations with families. They would have a loved one that was locked up pre-trial. There had not been any evidence put against the person, and there was a cash bond. Sometimes it was $50, sometimes it was $500, sometimes it was $5,000. And families would have to have this incredibly difficult conversation or this decision about whether to pay rent or pay for their loved one's freedom, pay a utility bill or pay for their loved one's freedom. And it's a conversation that we should not be having. We shouldn't be putting up people's freedom for ransom. And I am super, super excited that we got an opportunity to address that situation. So that's how I came to this conversation, as somebody who just defended thousands and thousands of people and just got tired and just got really tired.
Okay. Jacquie, how about you?
Well, again, thank you. I'm excited to be here, Julia. And similar to Sharon, I became a public defender because I wanted to help people. And you see very early on day one as a public defender, that we do not have an equal justice system. We have one for the wealthy and we have one for the poor. And you see, as a young public defender, sitting in arraignments where people are brought to the judge the day after their arrest in handcuffs, and the prosecutor asks to set bail in the amount of, all of my clients, most of my clients can't afford, and the judge setting that bail. And I turn to them and I say, well, you can plead not guilty today. Your bail is $500. If you can't afford that bail, you're going to go to OCCC, which is our jail here on Oahu, and you're going to stay there. You could be there for months. You could be there for years, until your case is resolved, until you have your trial or we dispose of it otherwise. And I'd see it in their face, and what that meant to them. And they're thinking about their jobs, their families, their children. And then you would look to the judge and the judge would say, well, counsel, if she wants to take care of her case today, if she pleads guilty, it's credit for time served, she's going to be released. And so they say, wait, if I plead guilty today, I'm going to be released? Yeah, but I'm innocent. But if I plead guilty, I can go home to my family? Yes. And so it's very clear then that our system is operating exactly how it was designed, to lock up as many Black and brown people as possible. In Hawaii, that means mostly Native Hawaiians and Pacific Islanders. An arrest is not just an arrest, and there's all these other issues driving people in the criminal justice system. And it becomes very clear that our money bail system is the driving force of mass incarceration.
Okay. I know we're going to be coming back to these issues. Bob, what has led you to have written the piece that you did for us, calling for the end of cash bail in Hawaii? What are the experiences that you've had? What have you witnessed within Hawaii's criminal justice system that led you to come to the sense that that was what was needed?
I was not a public defender. I never was. And in fact, I had a civil practice until I retired and didn't handle any criminal cases. But after I retired, somebody asked me to help get an inmate out of prison who on compassionate release. He was very, very ill. And I went to work on that, and that sort of introduced me to the criminal justice system. And the more I saw, the more concerned I became about what was happening to people in the system. And then when we learned around 2015 that the state was going to build a new jail, I was just, from a gut reaction, I just knew that was a wrong move because of what jails are and what they do, and the number and the way that people are treated in jail. So we do need a new jail in Honolulu, because the one we've got now, I mean, parts of it were built in 1921, and it's a terrible place. But we don't need the jail that the state is planning to build. We need a much smaller jail, and the reason that we have so many people in jail is because over half of them are pretrial detainees, are people who just can't pay bail. And so when I started looking at those numbers and this, the data and what jurisdictions around the country were doing, everyone that was considering whether they should build a new jail of some kind had to look at this idea that we had so many people in jail because they couldn't make bail, and how unjust that was, because the rich people who can afford bail aren't there. And particularly during the COVID pandemic, when our jail was so overcrowded, and I had a chance to meet some of the people who were getting out, it just became so obvious that we need, the only thing the way we can really move forward in the long run is to end money bail. And that will allow us to do a lot of things, and including building a very, very small jail for a few people who are dangerous, instead of this monstrosity that they're planning to build now that'll cost over, well, to be the biggest public works project in the history of the state. That the state is building, and it'll be $525 million. And of course, it's going to run way more than that when we get through. So, my interest is just having seen what jails do to people, see how unnecessary it is to cause all that suffering for people, to have people who haven't been convicted of any crime sitting in jail simply because they're poor, combined with Hawaii's really high homeless population, and knowing that a lot of those people who end up in jail come from a homeless background. A judge recently talked to me about, when the people come in and they have to set bail on Monday morning, that they've been locked up all weekend. She called it just, a parade of miserables, and it really is. And so I would just like to see us move forward and get rid of cash bail entirely.
Okay. And maybe just to distinguish for the viewers between a jail and a prison, that for anybody who isn't entirely clear on the difference between those two, the jail is where people go when they're awaiting trial. Is that correct? And then the prison is where you go after you've been convicted.
Essentially, yes. We have pretrial detainees in the jail, and we have a few people who have been sentenced to short terms. They may be a felony conviction, but they're sentenced to less than a year. They'll serve that time in the jail. And we have a lot of people in our jail, very uniquely, who are actually probation violators, who are in a program called HOPE. And that program ends up putting a lot of people in jail for short periods of time when they violated a term of their probation. And so at any given time, we have, between 200 and 300 people in jail, just serving maybe a week or 2 weeks or 3 weeks or a weekend because of a technical violation. And that's another, probably a third of the total jail population is made up of those people.
Okay.
And they haven't committed any new crimes.
Right. So let's talk now, if we can, about the bail system itself. And Sharone, maybe if you could lay out for people how the bail system functioned in Illinois, and what was it about the system that made you feel that it really needed to be not just reformed, but actually eliminated?
Yeah, that's a great question. We have a number of different counties here in Illinois that all do it a little bit different, but what they all shared was this, that people would be given an amount of money that they would have to pay. And given the current circumstances that we have with our economy, we have this incredible income inequality where someone may set a bail for $50 or $500 and think, oh, hey, that's easy to make. The person will make it. Because remember, bail is just supposed to be about getting the person to come back to court, right? So they'll set that bail amount, and then the person will stay. And the person will stay because they don't have the money to make it. So, we've seen a significant increase in pretrial incarceration, not just in Illinois, but in the entire country. Pretrial incarceration, that is incarceration before there's been a trial, is up 433% since 1970. And the main driver for that is bail. So what we've advocated for in Illinois and what we've been successful, the law will go into place in 2023, but it's already passed and signed by our governor, is that money will no longer play a role in detention decisions. Now, it'll be important that we do other things, and there are lots of other things in the bill to ensure that we're not just logging people into jail without a way to get out. But one of the key things is that we've eradicated the use of money. So money is no longer the main factor. So now we're not looking at our jail populations and saying, hey, those are the people that are poor, because that's what it is in the status quo. People remain in jail because they're poor, not because a judge says they have to be there.
Maybe you could just tell us, in theory, what is the purpose of bail?
Yeah, the purpose of bail is getting people to return to court. And, there's an idea that if you set a bail, then people will come back because of that bail. And we've seen study after study really proving up two things. That one, you have lots of people who get a money bail amount and they're never able to bond out. Like they never get out. So it's not like this idea that they, will just make the bond amount and come back. Just like Robert was talking about, the folks who are homeless and things of that nature, and all types of folks that just won't be able to get out. I think the second thing is that we've seen that bail isn't actually, money bail isn't a way to get people back to court, that it doesn't actually increase the likelihood of someone to get back to court. That if we want to make sure that people get back to court, first off, we have to realize that the vast majority of people will come back to court and do come back to court without any bail amounts. We see jurisdictions like DC and New Jersey, the federal system, the juvenile system, not having to use money, but also money actually is damaging and actually increases recidivism, right? When you're taking money out of a family's pockets, you actually increase the criminogenic factors that they face, right? You make it harder for them. So they may be forced to do things that society wants to do. And we also know that it's not just the money, right? That's not the main thing. You do things like remind people to come back to court, and you increase detention, or you teach appearance rates. Pulling money out of communities, pulling money out of people's pockets just doesn't get it done. And it's just an old process that we are happy to end.
Okay. Jacquie, could you, because you've been a public defender in Honolulu for 11 years, you spent a lot of time on the ground. You talked about it a little bit when you were introducing yourself and your feelings about cash bail, but can you really, because so few of us in Honolulu have an opportunity to go inside that world and understand it, can you tell us what it's like as a public defender? What are you witnessing? What are you seeing? What sorts of bail amounts? How frequently does bail get set in a case? How often are your clients actually able to make bail? What's happening?
Sure. So great question. Actually, a lot is happening. We are having incremental reforms. Starting most recently last year, there was some significant bail reform. Up until a few years ago, Hawaii used what's called, it's unconstitutional, but it's a schedule bail system. So essentially someone charged with a Class C felony would bail would be set just based on that charge, $2,000, Class B felony, $20,000. It would go up, and it was based on a schedule based off of what they were charged with. What the Constitution requires is that it's an individual assessment into a person's ability to pay. So we've seen some reforms around that recently, and now after someone is charged, there is supposed to be individual assessment into that person's ability to post bail. And bail, we're talking about bail in the sense of money bail. Bail before, when it was, I think it started in the 1800s, it didn't necessarily mean money. Bail was just a promise to return, and usually it was a family member saying, I'll make sure this person comes back. Since then, it has now become about money. But when you think about it, money has absolutely there's no proxy between money and dangerousness. So someone could be charged with a very violent offense. They could be a significant flight risk, right? And their bail is set at $2 million. Well, they're extremely wealthy, so they can post that no problem. But as a public defender, all my clients are indigent, meaning that they fall, below the poverty line, and even $500 to them is the equivalent of essentially no bail. They don't have the resources, they don't have the family, they're not able to come up with $500. And so, but they could be completely innocent, they could be non-dangerous. So it just, when you start really thinking about the purpose of it, money has, and you hear a lot of people, oh, well, public safety. Money bail has never been about public safety, because it allows a dangerous person to buy their way out. And so that's really, when you've been entrenched in the system, we have a lot of people profiting off this system, bail companies and judges, public defenders, prosecutors. This is what we do. This is normal. But when you really start to analyze it and think critically about it, the system itself just doesn't make sense, and it's not about public safety. And that's what we want to change. And that's why, we can do these minor reforms, but we really have to abolish the whole money bail system. We have to get where Illinois is, thanks to the advocacy and policy work of Sharone Mitchell, because, and I'm sure, and I don't know if we have time to talk about that, but I'm sure it was years of groundwork and movement building to get there. But they're there, and slowly. And this isn't the first wave of pretrial reform, of bail reform. It happened in the 1970s on a federal level. Most federal courts don't impose money as a condition of release. We saw it in DC in the 1990s. But Illinois will be the first state to completely abolish it. And that's where we need to go. It just makes sense.
Yeah, that's a great point. Let me just build on that just a little bit. I am one of literally thousands of people that have been fighting in Illinois for a significant period of time. My organization, the Illinois Justice Project, is a part of a coalition. It's called the Coalition to End Money Bond. I can let you guess what we're trying to do. And the Illinois Network for Pretrial Justice. And this is a story of really people across the spectrum, whether it's like dorky lawyers like me, or it's activists, or it's faith community leaders, service providers, just concerned neighbors that have all come together and demanded that this practice that is stolen literally millions of dollars out of communities that can least deserve, or at least afford to hit, and it's decided that this is enough. And we've organized and we fought, we filed lawsuits, we've tried to pass bills, we've lobbied our senators and our representatives, and after a significant period of time, we've gotten here. So it is not just me or my organization, it is a whole really coalition and network behind us that have gotten this done.
Okay. Can we talk a little bit about, so that the viewers can really understand the business of bail? You talk about millions of dollars being taken out of the communities, but how does that actually work? And Jackie, you were mentioning about a little bit about the origins of where the idea of money bail even came from. So how did, maybe Sharone, you want to speak to this? How did money bail actually get established? Did they have it in other Western democracies? And is there anything unique about the United States and the way that its money bail system works?
Yeah, I can handle it. I'll just say this. I'll take half of it. What is unique about the United States is that we have a private bail industry, right? Where we have companies that are essentially in business to accept payments, which are essentially ransoms for freedom. And there are only two nations in the world that do it like this. It is the United States, and I believe it's the Philippines, but I'm not exactly sure. Jackie can correct me on that. Okay, yeah. We're the only two states that have a private bail industry. Sorry, two countries that have a private bail industry.
Yeah, and there's some jurisdictions, and is Illinois one of the jurisdictions that got away from, you're not allowed to have private bond companies in Illinois, right? Here in Hawaii, though, we do have private bond companies. And so essentially how they grew out of, as I talked about before, the bail schedule that we had. So judges were setting bail amounts without an individual inquiry into how much this person could afford, right? And so then this bond companies, this privatization, capitalization, open market, they developed. And essentially how it works is bail is set in an amount, let's say $20,000. Okay, this person cannot afford that. So this bail company says, okay, well, if you can pay 10%, they normally charge a fee of 10% of the bond amount, the bail amount, it would be $2,000. So if the family can come up with $2,000, it's their ticket out of jail. So they essentially can buy their way out of jail. And what Sharone said is the United States is unique, is that we are one of two countries in the world that have this privatization, actual companies profiting off this pretrial injustice system. And it's a business. Many companies hold themselves out to be mom and pops, but they're often underwritten by large insurance companies, and they're extremely powerful lobbyists. And so we just have to get rid of the whole money system, because again, it's not about public safety. And so that's a little bit about how the bail industry works here. I mean, if judges were truly setting bail in the amount that an individual could afford, there would be no need for a bail company, if you think about it. If a person could afford $200 and bail was set in the amount of $200, and that was enough to ensure that they're likely going to come back to their court date because they want their $200 back, nobody would be in jail. But because there wasn't that individual assessment and bail amounts were being set higher than the person that couldn't afford, we have people sitting in pretrial detention. Now, there's so many other ways that we can, and better ways, because what people don't see and I think about is the violence of our jails. So our jails actually perpetuate violence. You're subjected to violence when you're in a jail. You could be sexually assaulted, you could be assaulted, you know, deaths occur within the first week more if it's going to happen. And so and then you have to talk about the collateral consequences of not being able to work. You may lose your job, you may lose your school. And we talked about how it can lead to wrongful convictions. And, you know, any defense attorney can tell you this, or someone involved in the system, but the outcomes are significantly worse for people who are held pre-trial than people who are out and able to fight their case. It's very difficult, especially right now with COVID, for even just the lawyers to have communication with their clients. And you're more likely to take a deal that maybe is not as good if you were out and you were able to work the case more and resolve it. And so there's all these inequalities and collateral consequences that happen when we talk about bail. And I've lost my train of thought what the original question was. But again, that's why I think in order to, we just have to get rid of the bail system completely and not these incremental reforms.
Okay, so here's a comment that's come in from Russell. He says, bail reform has been an absolute disaster. Every place it's been quote unquote reformed. This must not be allowed here. So there is someone who really thinks that bail reform clearly is not the way to go. Sharone, I would love it if you would speak to that, because I'm sure over the course of advocating for bail reform in Illinois, you encountered that sentiment a great deal.
Yeah, thank you so much for letting me handle the question. You know, I understand where Russell's coming from. We hear story after story from folks that are incentivized to kind of, you know, basically fight against this, kind of present this. So that's not true. First off, you know, I kind of hate the word bail reform. And the reason why is because it's not very descriptive of what we're trying to do here. In Illinois, what we did is eradicate the use of money bond. So if you want to call that bail reform, you can. But again, the using money, letting money being the mechanism to decide who should be in jail and who shouldn't is a completely broken model. And I would urge folks to look at what's happened in New Jersey. New Jersey essentially ended money bond. They only give out basically a couple in the state, and they were able to significantly reduce the amount of people in jail without any spike in crime. And the reason why they were able to do that is because of what we talked about today. The jail population is not indicative of who the people that are quote unquote dangerous in the community. The bail population tells us when we have a money bond system about who is poor. So we have lots of different systems that are able to do this. And one other thing I want to add is, you know, talking about, you know, it's been a disaster in other places. I would argue that it's been a disaster in places that haven't done it. So you won't hear on the newspaper, because it's just too hard, each story where a person couldn't make rent because they couldn't bail their loved one, or they had to bail their loved one out, or their loved one pled guilty and went to prison because they couldn't bond themselves out and actually fight their case. The really sad thing about this whole situation is that we aren't getting the coverage of the everyday disasters that go on because It just happens to people without power. And it happens in the most, it's just the minutia, it's just what we do every single day. And we're not used to thinking of that as a disaster. But I know in Illinois, we've talked to thousands of families, and literally we had a study done, $31 million have been taken out of families, right, pockets. And again, one more time, if you want to talk about public safety, what I would question is, then why are you propping up a system that allows for people to bond out if they have the money, right? Why are not we creating a system where judges are making a decision, and you've got to structure the system right? You can't just in money bond and go away. But why don't we structure a system where we're using risk and not money to make the decision about who's in jail and who's not? And I think New Jersey is a great example of a state that did it right.
Yeah, and just to add, I think there's a lot of confusion when you talk to people about getting rid of money bail. They think, well, everyone is just going to be released. Pretrial release should be the norm. The Supreme Court has said that people are presumed to be innocent, but there are some people that must be held because they pose such a significant risk of safety to the community. And that's called preventative detention. And that's, that shouldn't be based on money. And that's sort of the risk factor assessment that Sharone was talking about. But by abolishing money bail, all we're saying is we're not inquiring how much money you have to get released, because it's not a proxy for dangerousness. And that should be the inquiry. That should be the focus. Does this person pose a significant risk of danger? And if yes, have a hearing. And if it's found yes, then the person is detained. It just is not about money anymore.
If I could just jump in, Julia, very quickly on that very subject.
Sure.
In 2019, we had a task force that included the police chiefs of, I think, all of the counties, prosecutors from all of the counties, heavily weighted toward law enforcement people. And they studied our pretrial system, primarily the bail system here in Hawaii, for a year. And they issued their report in December 2018 for the 2019 legislature. And here is one of the things that they said, and I'll quote it here, if I may. They said there is virtually no correlation between the setting of a particular bail amount and whether the defendant will commit further crime or engage in violent behavior when released from custody. Thus, bail reform is a poor method of assessing and managing a defendant's risk. So that is what the law enforcement community and the prosecutors and members of the public who were on that task force said to the legislature. And I wish that the members of the legislature would pay more attention to that statement, that conclusion, and take it seriously and begin to move in the direction that Jacquie and Sharone have been talking about, because we have, the best minds that have looked at it in our jurisdiction have concluded that it is a bad system and doesn't work.
Yeah, it does seem like such a vitally important point to make, because I think most people instinctually, they have a kind of a sense that, well, somebody has a bail set because they shouldn't, they need to be, they need to be locked up. There's something about them that's dangerous, right? This is just sort of, that's what people see in the movies. That's what people see on television. And so you have this kind of non-scientific sense of how bail is set, why bail is set. So it seems like, as people who've seen the inside of the system, if bail is really designed for two purposes, A, to get whoever is accused to return for the trial, and B, to keep the public safe, what I'm hearing everybody say today is that money is just not the way to determine that. And in fact, is extremely devastating for more impoverished communities. So,
and I just want to point out what you said, because it's really important. What you see on TV, the person locked up, they're a danger. Okay, so just think about this for a moment, because bail is set in Hawaii and around the nation in nearly every single case. So if you have that money and you can buy your way out of jail, you're no longer a danger. like in the eyes of the community. You go right back to your community. But if you aren't, you're taken out of your community and you're in jail, and how people view you. And even more importantly, when you go and see the judge, I can't tell you, when I have a client who is able to come to court and close, have their family behind them, they seem part of the community, and it's harder for a judge to impose jail time then, because they feel like this person is a sense of our community, a part of our community. But when that person shows up to court in shackles and in a jumpsuit, and their family's not there, and right now it's even more devastating because a lot of that is done by Zoom. So you're not even, the judge doesn't even have to be present with them. It's so easy to impose that jail. It's almost like it means nothing to the person imposing that, and it's everything to that person. And so it's just you have to be aware of these consequences that that perpetuates, and how our society views poor people, and we're criminalizing poverty because of it.
So can you then speak to statistically, and then also in your experience, maybe you have the statistics, maybe your experience, but what percentage of your cases involve a violent crime, a charge of a violent crime versus a charge of a non-violent crime? So where bail is set?
Here in Hawaii, we have a low violent crime rate. We do. We have I would imagine compared to Chicago, we're very, very low. If you talk to any victim of a family who's, lost a loved one who was murdered, or, a family member, of course, one murder is too many. So I'm not minimizing that, but just like speaking statistically on a national level, Hawaii's crime rates as far as murders, sexual assaults are relatively low. But again, so bringing this back into the bail context, if someone poses a significant risk of danger to an individual or community, the prosecutors can move for no bail, because it shouldn't matter if the person is wealthy and money is going to be set and that person can buy their way out, right? That's what our bail system allows for. And so when we make the determination of whether to detain someone based on significant risk of danger versus money, public safety actually improves.
Right. So can you give us some examples of the types of charges that you are seeing bail set for, where you feel that the release of that person would in no way jeopardize the safety of the community?
So it actually has to be an individual assessment. And so again, it shouldn't be about just what the charge is, charged with a violent offense and not be violent and not be a danger to, pose a significant risk of danger. And so it's really an individual assessment. I would actually like to hear from Sharone about how Illinois did this, because I do have concerns about what happens. I do have concerns about risk assessments, because those have also been, they can also be racist. And so we don't want to replace one racist system with another, because risk assessments usually, they'll ask questions like age of first arrest, which we know poor communities are policed more. And people come into the criminal justice system at a younger age, and it perpetuates from there. Whether someone's houseless, there's all of these, the assessments themselves are racist. And so instead of, I believe it has to be an individual assessment into that, for that person, and not just based off of these assessments. But Sharone, since you did pass this, I would love to hear how Illinois handled this issue.
Yeah, so when it comes to risk assessments, and to explain to folks that may not be up on risk assessments, it's essentially an algorithm that a judge will use to help make her decision or his decision about what should happen. So they plug things into a computer and then use a bunch of previous, people smarter than me create this, previous outcomes to determine what should happen. This risk assessment, And here we'll create a score, and that score will tell us how likely that person is to either not come back to court, or how likely that person is to commit a new offense. And what we've done with risk assessments is we haven't banned them. I will be clear, Illinois and our judges are very fond of risk assessments, but what we've tried to do is we've tried to limit their use. So what the first important thing that we do is we say that risk assessments cannot be used as the sole determining factor for jail outcome, right? So you can't just plug some numbers into a computer and say this person should be in or this person should be out. This isn't Minority Report, the movie, where Judge Dredd. We have to have an individualized assessment. The second thing that we do is that we say the information that should be used in the risk assessment should be available to the attorney that's representing the accused person. And third, we say that the risk assessment should be able to be challenged. So a defense counsel should be able to say, hey, we think this risk assessment is done in a funky way and there are real problems with it. Let me present to the court the reasons why this risk assessment is broken or not. So that's what we did with risk assessments. I think to our question, Julia, and I'll let you go. I'll let you go.
No, I was just, I don't want to stop you. Maybe you can add to this or be part of that. As you're talking about the judges, I was just so curious what the reaction of the judges in Illinois has been to your movement. Have you found that the judges themselves were saying, we're enacting this system and we can see its flaws? Were you supported by the judges largely or not?
Yeah. So there's an Illinois, we have a Supreme Court who put together a blue ribbon commission, and they put together 53 recommendations. And many of those recommendations are found in the bill that we passed. And that report basically said that money should not be a deciding factor in whether somebody should be in or out. But I don't want to lie to you. There are thousands of judges in Illinois, and those judges are going to have some trouble, right? The use of money is ingrained in our system. It's built into our DNA. We see it on TV and movies. It's just something that we've gotten used to, that somebody gets accused of a crime and you've got to pay a bond, right? But the reality of the situation is that every practice has to be reformed. We did things in the 20s that we don't do in the 30s. We did things in the 50s that we don't do in the 80s, and so on and so forth. So what we did is that we created a 2-year implementation process, right? So we ended the bill, we ended cash bond, like we just voted on it and it just got signed last month. But there's a 2-year implementation period where the Supreme Court is going to go to jurisdiction and train judges and train prosecutors and train defense counsel on how to implement the system. I'd be lying to you if I said every judge in the state of Illinois were super excited to do this. There are certainly judges that are perfectly happy doing the things that they've always done. But again, this move was about the people. And it was about not just judges and prosecutors and even defense attorneys telling us how the justice system should work. It was the people who are subject to the justice system telling us how they want their world to be. And quite frankly, there were thousands and thousands of just regular people saying, I don't like the system. I don't want it to change. And that's the reason why we were able to do it.
Yeah, that's very empowering. One of the things I'd love to ask you, Jacquie, from, again, your experience on the ground in Honolulu, all of this has to do with pre-trial detention. And it really makes me wonder, we hear about sometimes, people they can't pay bail, so they get sent to OCCC. And we hear sometimes, well, they can be there for days or weeks or months or years. And so I'm thinking to myself, well, how long does it take to get a trial in Honolulu these days? So can you speak to that? When we talk about speedy trials, how fast are the courts moving in Honolulu at the moment?
Sure. Well, and again, we're in COVID, and there's a huge backlog of cases, and there's been a moratorium on jury trials up until recently. And so it has not been very speedy, but so I represent people only charged with the most serious of felonies. So we're talking about murder, sex assaults. So my experience is going to be different than someone who represents someone charged with, petty misdemeanor, misdemeanors offenses. But someone charged with a serious felony offense here, you can be pretrial for years. It's not uncommon. I have several murder cases right now that originate in 2019. So it's not uncommon for it to take years. Yes, someone can demand, and a speedy trial, it's 6 months. So the prosecutor has 6 months to get someone a trial. And if they don't, the defense attorney can move to dismiss. But when someone's facing, the possibility of life in prison, if convicted, you don't want to rush this. You want to fully investigate this. You want to, and that's going to take longer than 6 months. So an individual may waive speedy trial rights during that investigation preparatory stage. And so, you can be pre-trial in jail for years until your case is resolved.
Okay. Here's a question from James. I'm going to read it. It's a little bit lengthy, but do you think that Hawaii has a high functioning pretrial process compared to Illinois, or do you think Illinois is better than Hawaii? FYI, I am a bail agent. Of 18,000 HPD arrests, there were 450 pretrial persons at OCCC on January 31st of this year, less than 3% of total arrests. Does Chicago match these numbers? And he goes on to say, we have many ways to release persons in Hawaii besides money. We have OR, SR, and unsecured bail. You all know the high percentage the federal courts detain at 35%, 70%. How can state courts do that? How can Hawaii spend $65 million annually like Washington, D.C.? We need more ways to release people, not less. Why take away money when money, property, and credit cards work so well? So it seems like James is contending that, in fact, not very many people of the people who are arrested actually do go to jail because they can't make bail.
So I think that this should be a conversation that a community has with each other. So I will say something very quickly, and I will let the people who are in the community talk about. Here's the only thing I'll say. We can kind of talk about details about Illinois, Hawaii, DC, but I'll just target that last comment. Why take away money when money, property, and credit cards work so well? What we found in Illinois is that there are lots of people that it worked well for, but those weren't the people that had to pay. Those weren't the people that were getting millions and millions and millions of dollars taken out of their pocketbooks. They were unhappy that they had to pay $500 or $1,000 or $5,000, or they were unhappy that they were stuck in jail because they didn't have the same amount of dollars that another person had. Mm-hmm. And what they knew is that if they didn't get that person out of jail, or they didn't get themselves out of jail, they were far more likely to plead guilty and far more likely to serve a longer prison sentence. So when we ask these questions, I think we have to ask ourselves, who does it work well for? It may work well for folks that profit from the system, but others who are the brunt, or the business end of the stick, may not love it.
Right. Bob, do you want to speak to this, to what's happening inside the jails, and how many people are in OCCC today, let's say, because they're, by any measure, they would not be considered a threat to public safety, but they're there simply because they can't afford the bail.
Well, and also in answer to that kind of long comment or question that was asked, I think the problem is not whether we have a high functioning system or not. The question is whether the bail system is conceptually functional, whether it's right or wrong. I mean, if you incarcerate people who have not been convicted of a crime simply because they're poor, which is the essence of our system, that to me is wrong. And you can say you can make it work as well as you want, but if that's what it's doing and that's what it is going to do, then the system has to be wrong, and you can't tinker with trying to around the edges to try and make it more equitable. You can't make it equitable because it is inherently inequitable and inherently discriminatory against the poor, and discrimination on the basis of race, and works against the whole principle that people are innocent before proven guilty. So just want to put that sort of on the record with respect to that question. But one of the things we really haven't talked about, and that people who think our bail system is wonderful ought to consider, is I did just look up. As I said, we have, as of March 1st, 10 days ago, we had 891 people, pretrial detainees in jail. All of those people, I would say, are there because they're either struggling to get bail and they've just been admitted and can't make it so far, or they've been there for a long time and they're never going to get it. So those are people who can't pay bail. They don't have the money. And those people, okay, 891, as I said, because of the COVID pandemic, our jail population is way down. Our jail, it's 891 now, but it's typically around 1,100 to 1,200 on a typical day. That's what it was back in January before COVID hit. And back then, it was costing us on average, around $200,000 to $210,000 every single day to keep those people in jail. And so if you think about it, if we had to take $200,000 in cash and give it to somebody every single day, 365 days a year, maybe people would begin to think twice about it. And I think the other dynamic that is facing our community is that there is a commitment to building a new jail, which I support to some extent. It gets complicated because I don't think the jail should function when I use the word jail, building a new jail, I don't can envision building something like we've ever seen before, but that's a separate issue. But the point is that it costs so much to keep those people in jail. And if we're going to build a new facility of some kind, we're going to have to build beds for those people. That's the way the construction people talk about jails and prison, building it in terms of how many beds do you have. And we have never in Hawaii examined how can we build a much smaller jail. And if you start thinking about that, the first thing you look at is the factors that are driving the high jail population, which is bail. It's over half of the people. So if you consider just one person, if you want to build that bed for that person, it's going to be $380,000 just for each person that you plan to put in this new jail. So if you can reduce, also a statistic that's really important to remember here is that among our jail population, almost 74% of them, it varies, but generally 75% of them are charged with low-level offenses, Class C felonies or below. And so all of those people could presumably be bailed, if we would be released very easily if we didn't have the money bail system. Judges would find a way to ensure that they get released. So if you start reducing this $25 billion jail, we probably need a jail that's about a quarter of that and would cost a quarter of that. And, so I just kind of go crazy a little bit when I hear people talk about, well, we can't do this and that because of COVID. We don't have the revenues. The state is broke. We can't fund the oversight commission for our correctional system because we don't have enough money, even though it's only $300,000. Well, if you want more money, get rid of money bail because it's costing you, on average, I would say about $200,000 to $210,000 a day, and figure out a way to get those people out of jail who are pretrial detainees. Then you won't have to spend hundreds of millions of dollars to build the beds for those people who are innocent, because that's not where they belong.
So that's a really important point that you bring out, Bob, and thanks so much for mentioning that, the economics of the cost of imprisoning pretrial detainees that fall on us. And is that really what we want?
Exactly.
Yeah. I know one of the other pieces that you wrote last fall was looking at the conditions within OCCC and the fact that so many of the people there are suffering from mental illness, or are there simply, again, it's not only just the poverty that they're not able to pay the bill, but they may have been charged with a crime that arose from being homeless.
Oh,
So that essentially, that the jail functions as a poorhouse and as almost a sort of a state asylum. And do you see that same thing happening in Illinois, Sharone? Sharone?
Sorry, I was on mute. You know, I see that it will take us the entire 2 years to implement correctly what we tried to do.
Mhm.
I think that often we think about how we pass a bill and if we're going to pass it and if we're going to get the votes, and that's incredibly important. But we also have to, in the next 2 years, ensure that we implement this bill correctly. So I think that we've moved things in the right direction, and I would love to give great predictions about exactly what's going to happen. But what I think is going to happen is that it'll be dependent upon how well we implement and how well we get this thing done. And it won't be perfect the first day we get things going. It may not be perfect the second day, but we've got to be committed to this practice, and we'll see. You got to have me back on.
I would love that. And hopefully when you can actually be out in Hawaii in person. Well, we've been talking for almost an hour, but I do want to ask a couple more questions, if that's okay. And one of the things that I really want to bring out is what's happening in the legislature right at the moment with bail reform. Where are we? There was Bill 1260. And I don't know, Jackie or Bob, which of the two of you is more up on the latest with just what's alive at the legislature and what that bill would do?
I can speak briefly to, it's called Senate Bill 1260. It is past the Senate now and has gone over to the House. It is a bill that would eliminate money bail for, just to want to be sure, use the right terminology here, traffic offenses, violations, nonviolent petty misdemeanors, and nonviolent misdemeanors. Those people would all be released on their own recognizance with or without conditions. However, the bill does not apply to a lot of misdemeanor and petty misdemeanor offenses. It does not include any, in other words, bail would still be applicable to people charged with assault, terroristic threatening, sexual assault, abuse of a family or household member, violation of a temporary restraining order or a protective order, anybody who is charged with driving under the influence, negligent homicide, or any other violent crime. And then there's a whole list of other conditions where the judge could deny bail, even for misdemeanor and petty misdemeanor, such as if the defendant has a history of non-appearance, if they have one prior conviction for a misdemeanor crime of violence or a felony crime of violence within the past 10 years, and it goes on and on. There's all of these conditions. So, I mean, I think the bill is a good one in the sense that it will start the ball rolling, and maybe we can collect data to show how effective we can be without having money bail. And maybe that's what we need to convince some people. But I really support this bill, but I think it's a baby step in the right direction. And it's more of a pilot program than anything else. but we need it. We should take what we can get this session if the bill passes.
Yeah. But very preliminary when you consider what they did in Illinois. Yeah. So here is a question from Denise. She's asking, who or which department sets the money amount for bail? It seems HPD / the judges / the court system makes up their own bail amount? ? So who's deciding?
So when someone's arrested, HPD will set an initial bail amount. So a person can actually bail out when they're in police custody prior to seeing a jail if they have the money. And if not, then they come in front of the judge, and the prosecutor will ask for a certain amount of money, and the judge then sets the bail amount in the case.
Okay. I would love to ask each of you for just any closing thoughts about where we are, where we need to be going. Bob, can we start? Is there anything that we haven't mentioned in this conversation that you think needs to be brought forth?
I think we've hit all the main points, and it just it's a real education for me to listen to Jacquie and Sharone because they know so much about this. I just think the present status is that we've got such a long way to go. We are, there are a lot of jurisdictions that are ahead of us. But particularly the jurisdictions that are thinking about building a new jail, those are the ones that are really serious about bail reform, because that's more than half of your population. And if you can deal with that, you can save yourself millions every day and in construction costs and be more just. So I think that's the main takeaway that as I see it. And we're just going to have to keep struggling until we get to the point that Illinois is at. And I'm so glad Sharone was able to join us, because they have just done such a remarkable thing. I mean, they're the real groundbreakers, and they're committed to making this work. You can tell that they're taking time to implement it correctly. And what a great model for us. And I really appreciate Sharone coming on and sharing what Illinois has done, because it's so important for us to hear that.
Okay, thanks, Bob. Jacquie.
Likewise, and well, thank you, Civil Beat, for allowing this platform and having this conversation. I do realize it's a difficult conversation. There's a lot of fear around this. There's also a lot of people profiting from the current system and a lot of pushback. There's a lot of movement building we need to do here locally. I'm always here to talk with. I love to engage in these conversations with community members as well as law enforcement. So please reach out to me anytime. And Sharone, I can't thank you enough. It's like, I'm thrilled to have met you and to just listen to you. It's just very exciting to see that it's possible. You did it. And thank you for all your work on the ground in Illinois, and congratulations on your nomination to becoming the public defender in Cook County. That's really exciting. And so, and Bob, it's always a pleasure to join you in conversation. And Julia, thank you again for hosting this.
Sure. Sharone, we want to give you the last word.
Yeah, I'll just say I'm super proud of what Illinois has done, but we're really 50% way there. We've passed the law. The law has not, been implemented yet. We're gonna wait until 2023 to see what happens. But I think it's important for local communities to have their conversations with themselves. That's what we did here in Illinois, and it'll take really folks, just people kind of coming around and saying, we're done with this practice. I think that is the biggest takeaway from Illinois. Not so much the law that we passed. I think we passed a really strong law that kind of changed the whole system, but it is about like really individual folks coming together, not fancy folks in the ivory towers. Well, really, there were fancy folks in the ivory towers, but they combined with people on the street from the community. They were instructed. They took directions from those folks who really faced those ills, and really created a beautiful coalition and a beautiful network. And we're able to get some change, not because the folks who were in power wanted it to change, but because the people decided that was enough.
Yeah. And I have to say, I think that is such a powerful message that you shared with us today, that this was really a people-driven initiative, and that's how you got it through.
It was about organizing, right? Lawyers can tell you how the world can work, and they'll interpret the law, but organizers define, they create what's possible. And this was done, as one of the comments talked about, with organizing. And we were so happy to be led by such great organizers.
Yeah, that's great. Well, all of the best to all of you there. I want to thank the viewers for joining us today, and we will be back on Wednesday, March 24th, will be our next Ideas Live show. Until then, we wish you all of the best. And one last time, we want to say the greatest of thanks to Bob and Jacquie and Sharone. Be well, everyone. Aloha.
Thank you. Thank you, Julia.